Artists are suing for their futures. The AI boom scraped millions of creative works without consent, and now copyright law is catching up. 3 pioneering lawsuits, 1 landmark court battle, and what it means when your work becomes training data. In January 2023, 3 artists, Sarah Anderson, Kelly McKernan, and Carla Ortiz, filed a landmark lawsuit against Midjourney and Stability AI. Their claim: simple but powerful, the companies scraped their artwork without permission and used it to train image generation models. The lawsuit is now moving through US federal court, and it challenges the fundamental assumption that AI training is always legal. But this is not an isolated case. Illustrator and activist Molly Crabapple documented how her portfolio was scraped without consent in 2022. She watched her style, her technique, her work absorbed into a machine. No permission, no negotiation, no compensation. The ethical argument is stark. Creative workers, artists, illustrators, photographers spent years, sometimes decades, building their craft. When a generative AI model learns from your work without consent, it is profiting from your labor. It is copying your style, your voice, your unique contribution to visual culture. What makes this moment critical is the recognition that consent matters. Copyright exists to protect creators, not just corporations. And when you create something, a painting, a photograph, a character design, that work belongs to you. The legal question is really not whether AI can learn, it is whether it can learn from you without asking. There is another layer to this. In 2024, OpenAI CTO Mira Murati sparked outrage when she said that creative jobs destroyed by AI should not have existed in the first place. Think about that statement. It dismisses years of skill, years of creative struggle, and reduces human artistry to something disposable. This is not about progress, it is about power. Who gets to decide what work has value? Who benefits from creativity, and who bears the cost? Meanwhile, in April 2026, Anthropic withheld its Ethos AI model from public release, citing cybersecurity risks. Here is an interesting contrast. A company chose to hold back a powerful technology because it could cause harm. This is an ethical decision. It prioritizes responsibility over profit margins. Now ask, why cannot the same standard apply to generative AI trained on unconsented creative work? The lawsuits matter because they force this conversation into the courtroom. They transform an abstract ethical argument into a legal question, and they give creators a chance to fight back. If you create anything, art, writing, music, these lawsuits are defending your right to consent. They are arguing that your work has value, and that value should not be extracted without your permission. This is not just about artists. It is about acknowledging that human creativity, human labor, human skills still matter in an age of artificial intelligence. On a practical level, if you share your creative work online, these cases show why documentation matters. Keep records of where your work appears, when it was posted, and what rights you granted. This becomes evidence. And if you care about this issue, whether you create or not, pay attention to these lawsuits. Their outcome will shape how AI development is regulated for the next decade. The ethical dimension is even deeper. What kind of AI future do we want? One where machines learn from stolen labor, or one where creativity is respected, where artists have agency, and where consent is not an afterthought but a foundation? This was Cyber Ethos. Stay curious, stay critical, and until next time.